once in a while, I'm real push back. For the most part, well, I always start with this is the way people call it. Just express it. What I used to do you're always good on the altar because everything you write though, it's obvious the one is like I can always tell the one. Because that one's always like this one's still the best. This one's got some glitter, you know, and it's all the other one's like it's sort of like salesmen. We have the good, better, and best. And this is why you should buy the Streamliner guitar. This will protect your leather for 6,000 years. You know, put this one down here. Yeah, you're right. I want this one. Like in a Christmas story with the tree. This is a tree. He has it like all the deals. He money for all of it collectively. After my daughter watched the 24-hour Christmas stories, and it's pretty funny. It's a great show. The only thing I can watch over and over again is the Santa Claus when he goes, when the boys slide down the, Robbie slide down the sliding ramp zones when he goes, is it when football? He goes, no, I want to be or Daisy Red Ryder or whatever, you know, Compass and Style, whatever. And then Santa looks at him, he goes, put your eye out. And he has his foot, he goes, oh, he taps the kid's head, he goes, right down the slide. That's one of my favorites. That one in Christmas Vacation. It's so good. And that goofy ride that Clark takes on the remember that he has that saucer made of special materials. And even worse movie than that was the French Restaurant is the actor who played the French that's so fun. And the guy's like, maybe you should. And then they translate it for you. And he's like being all great saying it's like American people just this thing too, so they show the kitchen. And they serve the French people like really good food. It's not the microwave, they stick your French food like it. Because it's not too far. It's not too far from the trees. They just put her in a chair. It's really bad. The scene with John, the cameo of John Candy, the fact that what makes the movie at the end, what really makes it is that Clark gets his shoes put up. Okay, we're going to start, and I want to welcome all of you back. No 2-hour delay today, so depending on your perspective, it's good. No, actually, I'm really happy about that because I wouldn't have wanted to lose the time. So I'm happy that we're back here again today. We're going to pick up where we left off. A couple of things. So coming in this morning, just an anecdote. I came in this morning on the metro, and I was behind all these tourists who were driving me crazy, with not being able to operate the ticket machine. And then actually at the Roslyn Metro, a wife was yelling down the stairs to her husband, who was halfway, maybe a quarter of the way down the stairs. And Roslyn Metro is huge. The escalator's huge. He starts walking back up the downstairs as he's talking to her about which direction they're going to go. And now Roslyn only has one track. And I'm assuming they're not going to Vienna for the day to see the sights there. They're going into Washington, D.C. So that narrows it down some. So as I was being very smug and all awash in my hubris over how superior I was to them for being able to use the metro, I thought back to my own experience this summer when I went to Montreal, and I was the idiot trying to operate the ticket machine and had no idea, and like 50 people behind me rolling their eyes at the dumb American who can't figure out how to get a ticket out of the machine. So it was just kind of funny when those things cross your mind, if you sometimes think that, well, sometimes you're going to be the person who's... But I never walked up the down escalator, so, Yeah. So as far as today's proceedings go, we're going to pick up. David was discussing state authorization yesterday. Do want to just kind of reiterate something, and I think for those of us who have been negotiators at the main committee, it's hard to get out of this mindset of consensus, because that's always what you're seeking at the main committee. And I just want to remind everybody, and I'm reminding myself, that that's not what we're doing here. So we're trying to make recommendations to the main committee, and I think that in order to do that, we don't need consensus, which again is not to say that we're in any way going to disparage an opinion that's a minority opinion. We're going to make sure that all the way the entire group thought is reported out. But I don't think that should preclude us from if most of us can come up with something we think is a recommendation. We'll get the other side of it as well, and then we can move on. But I don't want to get bogged down in all of us trying to convince everybody that we need to vote a certain way, because that's just not what these subcommittees are about. So I just want to point that out. Do you want to say something?
Well, and we had talked about this yesterday, but in order to facilitate getting through topics and getting discussion out there, the ones that we think that you guys think you might want to propose alternate language, we remind everybody we have another month for people to think about that and do that, so we don't necessarily have to sit here and work on language right now. Instead, we should probably get through and get everybody's opinions out on as many topics as possible. Right.
So with that, I'm going to turn it over to David to continue his discussion on state authorization.
Right. David, excuse me. I noticed that Sue has her placket up. Maybe she wanted to make a fast comment.
No.
Okay, so there was a lot of conversation going on last night right before we left on state authorization, and I think this is our opportunity to get it right. It's caused a lot of unintended consequences. We have been concerned about our student consumer protection. The way that it was before, I think there were a number of things that the department did to help facilitate this, and from that we came about with state authorization reciprocity agreements. But I do have some questions. You made the statement yesterday. We are thinking of, I believe you said, completely eliminating state authorization language.
Well, yeah, and I want to address that too, because I think leadership's position is a bit different after hearing some of the conversations yesterday. So let me talk through where we stand right now. Right now, leadership is interested in hearing from this table and from all of you what you think is important to keep from those old regulations, from the regulations that were promulgated in 2016, and what needs to be changed. We heard quite a bit of support for maintaining the concept of state authorization for distance ed, as well as the concept of reciprocity, while we also heard the need for some significant changes in some parts of the regulation as it's currently written. So if that is the case, we'd like to hear from folks at the table, number one, what are the most important things to keep from the regulatory language as it exists, even though it's not implemented right now, as it currently exists, and what really needs to be changed or eliminated in the views of the subcommittee members. So we'd like to have that conversation this morning so that we can kind of come up with the things that we might want to hold on to, because we got the impression yesterday that there was a sense that this was actually quite important, and that not all of it really needed to be scrapped. So we can have that conversation now.
Just a quick question, because right now we're in the definition section. Yeah.
Yeah, so what I'd like to do, if we are willing to have that conversation this morning, is to cover all of the sections that relate to state authorization. So that would include this definition in 600.2, the language in 600.9 C, which again is not currently implemented, but it is redlined and it's in your materials, and then also the language on disclosures in 34 CFR 668.50, which again was added in 2016 but has not been implemented yet. It's been delayed. But those are the areas that I think we can look at to determine whether we want to keep any of it or whether we should remove or change the language that's there. So I think it might actually be helpful. We started at this discussion because we started talking about the reciprocity agreement definition. It may be helpful for us to look at 600.9 and have me explain briefly what that does and how the reciprocity definition connects with that. So if you guys could turn to 600.9, and I have to find it in my own materials here, so give me a sec. Is it 13 or 14? 14. So it's page 14 of the Part 600 red line edits.
13?
And whenever you guys are ready, I'll get started.
14. Oh, yes. The red line.
Okay. All right, so as you guys are getting the section and maybe taking a moment to read it, essentially what the language in 34 CFR 600.9C does is it creates requirements for an institution to be authorized in all states in which it operates, including under a reciprocity agreement between states, in which states recognize the institution's authorization in the state in which it's physically located. The regulations also require a complaint process to be in place for students in all of the states in which the institution is operating. Russ mentioned that there have been some concerns about the language that's there about where each student resides as opposed to where each student is located, and of course we can take a look at that. But that's the general concept, is that before these regulations were promulgated we negotiated it in 2014 and we actually published the regulation in 2016, there was no federal regulation that looked at what state laws existed regarding authorization for students who were living in a state and taking coursework through distance education from an institution that's located in another state. So if you're living, let's say, in Montana, and an institution also is in Montana, there's not really a problem in most cases because the state has authority over the physical institution in Montana. But the federal the regulations didn't address cases where the student was living in Montana and the institution was in Arizona, and Montana had some requirements for the student who was living in their own state and attending through distance ed in another state. So this regulation was intended to address that and give a federal hook to say that if Montana says that you can't operate in Montana, then the students in Montana would not be Title IV eligible. even without this regulation, as Russ pointed out yesterday, all of the state rules would still apply. None of this affects the state's ability to create and enforce their own laws regarding distance education, but this connects the state laws to the federal, to students' federal Title IV eligibility, and that's also why we created a definition of state reciprocity, because that outlines what the department considers the necessary requirements to have a reciprocity agreement that meets the definition of state authorization. The other thing, and we'll get to this in a second, but I think I'm going to hold for a moment and talk and answer questions. But the last thing that we did in the 2016 regulations was we promulgated a number of disclosure requirements that institutions were required to make for students who were in 100% distance education or correspondence programs. But I think I'm going to hold on that until we have talked through this part first. So does anybody have any questions? Anything I can clarify about the language that's in there right now? It's all perfectly clear. Good. Okay.
Okay.
So procedurally, do you want to just go through each one of these under 600.9 and discuss them? Is that what we want to do?
Yeah, we can do that. Yeah, let's try and do it that way. Let's talk through 600.9 first, and then once we're done with that, I'd like to go to 600.2, where we talk about the definition of a reciprocity agreement, and then I think we can go to 668.50 to talk about that. And like I said before, what I'd like to do is to figure out what you guys think are the things that are really problematic in this regulation, what you think is really important, and what, if anything, you think we could do to change it to make it work better for schools, students, et cetera.
Jessica.
All right.
Thank you. I just wanted to point out that so this negotiated rulemaking for this, I wasn't there, but I understand some or many of you in the room was in early 2014, and from the lens of fraud and harm to students, we live in a totally different world. As I know you all know, there are many large institutional chains that will not be named but no longer exist, and I would say hundreds of thousands of students who've been left stranded. Many of you know there was, I think last week or the week before, a 49 state attorney general settlement, with the 50th state having previously settled. So I think the concerns of fraud were present and a factor in the 2014 rules, but I think it's just so critical now that we know where we are 5 years later that we preserve or strengthen that.
All right, so let's go through the language, and we'll look at each section step by step and take comments. We're not going to go into language or anything like that at this point, because I want you guys to think about it, and we need to think about it too. But again, generally, what are the things that are problematic in each section as we go? So start with C1, Romanet 1. If an institution that meets the requirements under paragraph A1, which, by the way, is the physical location requirements for state authorization, offers post-secondary education through distance education or correspondence students to students residing in a state in which the institution is not physically located, or in which the institution is otherwise subject to that state's jurisdiction as determined by that state, except as provided in paragraph C1, Romanet 2, which we'll get to, of this section, the institution must meet any of that state's requirements for it to be legally offering post-secondary distance education or correspondence courses in that state. The institution must, upon request, document the state's approval to the secretary, or, and I'll go down to 2 here, Romanet 2. If an institution that meets the requirements under A1 offers post-secondary education through distance education or correspondence students in a state that participates in a state authorization reciprocity agreement, and that's defined back in 600.2, if you'll recall, and the institution is covered by such agreement, the institution is considered to meet state requirements for it to be legally offering post-secondary distance education or correspondence courses in that state, subject to any limitations in that agreement and to any additional requirements of that state. The institution must, upon request, document its coverage under such agreement to the secretary. So the documentation part is just an audit requirement. We need the institution to be able to show us that it's eligible if we have this requirement. And I'll stop there and let you guys think through that.
right, Russell.
So you had mentioned I had brought up the location versus reside thing, and that was Leah and I and Carolyn were on the 2014 committee, and in that we had clarified that it was student location because that matches better with almost all state laws and what they do in that. And we had written several letters about clarification because there seem to be some things if you take students' residence and do that, let me use an example, that if I'm a Colorado person in the military, that I'm in Texas, and that's where I'm stationed, but I'm taking courses from an institution in Maryland, let's say, that Texas law is the one that covers it because that's where I'm located, even though I'm a resident of Colorado, and people get confused about that. And it seemed to imply in this that the institutions were to tell the student to go back to Colorado because that's where that was my home residence. And so we thought that was, sort of putting in some things. So we were hoping that we could fix that location versus residence issue.
Okay. Yeah, we heard that from the letters that you guys sent more recently. One thing that that leadership is concerned about regarding the location concept is that locations change, and I think we have an interest in trying to determine at one time where the student is located so that institutions are not required to continue monitoring where their students live all of the time. So one proposal might be that it's the language changes to where students are located, but we put in some kind of limiting language that says the institutions check for it at the time of the student's enrollment or something like that, because we just don't think it's manageable to have the schools checking for students where they live over the course of their entire education.
Go ahead, Russell.
Can I just ask, when you say at the time of enrollment, do you mean at the time of admission or at the time of each course enrollment?
Well, we're open to ideas, but we had envisioned at the time of admission.
Yeah, and under the 2010 guidance, I think that sounds reasonable, doing something like that. And under the 2010 guidance, I think they did it at the time that you determine financial aid eligibility. That was another way that they did it back then, if you go back to the old guidance. But something like that makes perfect sense because you need to have a census point.
David?
So I agree. Point of admission is the right thing. The other thing that, and maybe this isn't the right time to talk about it, David, but the other thing that concerns me is just issues of access. Because, I know from institutions where I've worked, if states charge too much money and we only have a couple of students who want to enroll in our programs, we tell those students you can't come. That's not doing the student a service. So I am concerned about that. I don't know how we solve it, but
in your experience, were those states in a reciprocity agreement or not when you saw those fees?
Well, because the reciprocity stuff was sort of coming in, initially, no.
So I just pulled up the fees, just so everybody knows, with respect to Sarah. I just pulled it up while we were, because I was thinking of that too. So it says $2,000 a year for institutions with fewer than 2,500 students, $4,000 a year for institutions between 2,500 and 10,000 students, and then $6,000 a year for institutions over that threshold. So I just wanted to make sure everybody was aware of sort of what we were talking about. Sorry, I'm losing my voice, I guess, after this week. Sorry.
And do we remember if, for instance, Massachusetts in particular is in a reciprocity?
So all states are except California.
Okay.
Yep.
Sue?
Yes, and just to build on what David said, we had the same situation with some of our programs. We did have to stop sending medical students to certain states because they were not part early on of the reciprocity agreement.
Jessica?
I just point out that amount of money is often less than one semester's worth of tuition.
Any other thoughts about the wording or the concepts in that part of the definition, part of the state authorization requirements regarding what's required for a school to be authorized? If not, we can move on to the next section. Carolyn?
I just wanted to point out that obviously this references state reciprocity agreements, which are defined in a different section, which perhaps we could talk about at a different time. But my concern about the definition of the state reciprocity agreement, I just wanted to note, which is that it is the way it is worded now. I should say the way it was worded and then was. Are we going to discuss it at a different time, or would you prefer that I hold my comments? Or?
If it's about the definition of the reciprocity agreement itself, then yeah, we're going to get to it in just a second.
Then I will hold my comment, other than to say that since these are obviously connected, that my concern would hinges on how it is defined.
So let me go on to 2 here, and this is 600.9C2. If an institution that meets the requirements, again, offers post-secondary education to students residing in a state, they must document. I think we went through that. So it's in each state in which the institution's enrolled students reside, and we can make changes to say located with the kind of provisions that we just talked about, or through that reciprocity agreement. So if everyone's okay with that language, then let's go back. We can go back to 600.2 and take a look at the definition, because a lot of this hinges on the reciprocity agreements themselves. All right, so then I'll go ahead and read the definition here. A state authorization reciprocity agreement is an agreement between 2 or more states that authorizes an institution located and legally authorized in the state covered by the agreement to provide post-secondary education through distance education or correspondence courses to students residing in other states covered by the agreement, and does not prohibit any state in the agreement from enforcing its own statutes and regulations, whether general or specifically directed at all or a subgroup of educational institutions. And now I'll pause.
Marty.
This is probably a question for Carolyn. I'm interested in the latter part of that comment that says it does not prohibit any state in the agreement from enforcing its own statutes and regulations. I'm trying to figure out what that might mean once you're in a reciprocity agreement, how that might happen and how.
Well, the way it is structured right now, the language of the reciprocity agreement permits or says that, acknowledges, I don't know what the right word is, that states can apply laws of general application to SARA state members that are located outside their state but operating in their state. So let's say a school is operating in my state, New York, and they're defrauding students. Under New York law, they're violating New York law. So I personally know my office in my state can bring an enforcement action against that school to enforce our law and get whatever relief is available under that law. So we can get an injunction preventing them from committing more fraud. We can get restitution maybe for consumers, that kind of thing. And the way it's written, I'm sorry.
So this does not mean that if we were in a reciprocity agreement with New York, that New York said, okay, we accepted that, but now we've decided to set this other standard outside of that on all institutions. I'm trying to figure out.
Well, that's sort of that is part of the issue here. So like in New York State, for example, there are specific New York State education laws that have existed prior to the existence of SARA, and that require, let's say, certain things to appear in an enrollment agreement, or certain disclosures to be made, or in certain states there are restitution funds. In other states there are bond requirements, so that when things go terribly wrong because there's a bad actor or there's a closure, there can be ensured that there's going to be adequate relief for the consumer, for the student. So those things apply to all schools who operate in New York, and if there isn't language that permits New York to enforce those laws against everyone operating in New York, it creates a weird two-tiered system where our office can protect, using our laws, students who are enrolled in some programs in New York, but not other programs that are in New York, and that raises serious concerns only because there are bad actors that we're quite aware of that operate in the space.
So I think I'm still trying to get to this piece coming out of, and a year ago I was part of the SARA discussions in New York, but trying to figure out how New York would protect itself entering in with an institution in a SARA agreement at the front end to say, okay, this, and then you have New Jersey, you have everybody in that same agreement, that the institutions don't get surprised then that we think we're in a reciprocity agreement, and $6,000 does seem like a pretty good deal to get this done. But now suddenly we have all these states still coming out with their own requirements on top of that, which pretty much undermine their SARA agreement.
So at this point, it might be helpful to go back to a letter that the department sent to Russ and others on this topic, in which we tried to explain the applicability of these regulations in cases where there were conflicts. And Scott, I sent you this a link to this letter earlier. We might want to just print it out and have folks. Yeah, okay, great. But yeah, so. As you can see, I'm using my computer right now, so I'm not getting. So we sent a letter that essentially said that the states need to work out any kind of disagreement between the state laws and the reciprocity agreement, and to the extent that they haven't worked that out, then the department doesn't necessarily recognize the reciprocity in that state. So we don't have any ability to supersede state law in the department. So that was the position that was taken regarding this requirement. We can say that when state law applies, we can connect our requirements to that, and in fact we do in this regulation. But if the states say we don't recognize you reciprocity, or our laws supersede the reciprocity, or something else, we will defer to the states on those types of decisions. So that's the policy that's been established. That's not to say that we can't adjust that policy, but that letter kind of establishes how this would work, or would have worked, if the 2016 regulations had been implemented.
Well, I think that's the only point I want to put out, because I do think sometimes we look at SARA and say, oh, we have it all covered because we now have SARA. And I don't think we have 50 states and the territories that can't come to an agreement, trying to get however many IHEs there are to come to compliance with that. So I just wanted out there that SARA is not necessarily the answer to everything, that there's still opportunity for the institutions to get caught up in changing rules and non-compliance and things like that.
Russell, did you want to? Go ahead.
So what do you do in a situation, I'm sorry, I forgot. What do you do in a situation where you do have the different states? Have you gotten into disagreements? Have you gotten into litigation? What have you done when you have a situation where they have a different requirement? New Jersey, whatever state it is a different requirement, and you guys you haven't gotten there.
Well, so far we have used our laws of general application, which there is not a controversy about. There just isn't like nobody has said that we can't apply our unfair and deceptive actresses law. So we haven't applied education law violations where we would otherwise have. So in other words, we have not used our full arsenal of tools of enforcement that we would otherwise be able to use if a school were operating in New York. To be honest, we haven't actually had this situation. I'm sort of talking hypothetically. I don't think that the schools that we have investigated settled with, or otherwise, for the most part, I think have a presence in our state, as opposed to a strictly Sarah school. So I don't think this has totally been tested, but I think that the approach would be that we wouldn't be, that we would take the position that it would be, that there's no issue with us applying our laws about deceptive practices and fraud, but that there is a concern that we would not be able to apply other laws like education, specifically coming out of our education law, that would, for example, relate to reimbursement, disclosures, those sort of things. I don't know if that helps.
No, it does. And I know New York has they have stringent laws.
Right. So we have sort of, we see it in sort of two buckets. There's sort of the general fraud and illegalities and whatever that applies to everything. And then there's education law.
Right. Okay. Thank you.
Russell?
Okay. Thank you. That just a couple other background things about SARA, that it is voluntary for states to join and voluntary for states to be part of that. So for New York to be part of SARA, that meant that there was legislative action that was signed by the governor to go through. That legislative action, and the governor chose this two-tier system, that they chose to be part of that, chose to do this. So this would, go against what's being proposed, would go against what was legislated and agreed to by the state. And so it's, and if they wanted to, that there are some ways to change it, that there's ones that they could go through SARA and try to get the rules changed, but that's something where it's an agreement among the states, and so you would have to get that going. And I'm not aware that has happened, but maybe it has. But that is an option, to go through the SARA process and get that done. And then the other option is for the state to leave and decide not to be part of SARA. So that's another way that they go. But I kind of agree with, or I fully agree with what Meredy was getting at, that the idea for reciprocity was that you have all agreed to use the same standards, all agreed to use the same rules, all across the member states. If you make it so that, well, except each state can make different rules on top of that, we're back to where we were prior to that, and then we don't really have reciprocity. So.
Okay. So, Jody, do you have? Okay. So, Jillian.
I just want to ask, do any of us represent institutions that have a large distance ed population and are not SARA members? Any of us? If we have large distance ed populations and we're not SARA, like from an institutional perspective, I know.
Well, non-degree granting are not eligible for SARA. So if you're a non-degree granting institution in distance ed participating in Title IV, you go to all 50 states right now.
Yep.
Reciprocity is only at degree granting levels. You can be a degree granting institution with non-degree programs and be part of SARA, but this has been brought to me as a matter for any non-degree seeking distance ed program, certificates and diplomas. They have to work with all states at whatever typically the career technical division of the state in that regard.
I just think it's maybe an important voice. Sorry, Jody. Maybe it's an important voice that isn't represented around this table, because I think those of us seated here from institutions that have large online populations, I think are all SARA members. So I don't know. I know in the larger committee protocols, there's an opportunity for the subcommittee to bring in, I think it's called an expert, to join the subcommittee. And I guess I would just propose for the next session that we think about bringing in an institutional representative on this topic who can speak from a non-SARA perspective, because I just feel like I'm not super equipped to be able to represent entirely accurately that perspective, since we're SARA members. So I don't know if people have thoughts on that, but would welcome feedback.
We'll take that suggestion back.
Sure. Just speaking from Iowa, and Denise, I think this goes to your question. Our state AG and the New York State AG were very concerned about what they call dumbing down the requirements from student consumer protection to general consumer protection. And this came to light when our state portal agency filled out the application, which you can find on the SARA website, and you have to check off that you agree to certain requirements. So this is where it comes to light in some of the states, because you are saying that you, and I'm trying to find, I believe it used to be question number 7, and now they've redone the form, but you say you are waiving that state right and that you will go with wherever the student is. So that was a major issue. And again, to answer your question, how are we working around that? Our state AG and our governor came together and they had tobacco settlement dollars that they set aside into a fund to protect student consumer protection, because it was a main issue. Took a couple of sessions to get it through for us to be able to join SARA.
Thank you. Jessica?
Thank you. Just a couple quick points. One is, you know, from a student perspective, I think, you know, we're worried about the balance right now between the ease that comes with SARA, which I totally acknowledge is real and also way outside my expertise, and the dramatic amount of things that must be waived in order to join. And I think, you know, that's the balance is what we're worried about. And just to, I think maybe to bring this like a little concrete, I represent dozens of students who run into refund problems. So they enroll, they're low-income students, they can't pay out of pocket, they enroll in a school solely on Title IV funds. It's a predatory school. They realize, you know, in the second week of class that it's not good. They drop out. Because of the R2T4 rules versus the school refund rules, they now owe a tuition debt to the institution that's often 50 or 100% of the semester's tuition. They don't have the money to pay out of pocket because they never had the money to pay out of pocket in the first place. They get sued. They have a judgment. They're now low-income workers whose wages are getting garnished. And so if you think about like that chain of events, refund is one of the issues that SARA requires states to waive. And I think we could all imagine that a state would have an interest in its students having certain refund rights. And so I think, you know, obviously there are compliance issues, but I think that's an example of the kind of topic we're talking about, where I think we could find a balance between the ease of compliance versus the protections for students that states themselves impose.
Carolyn?
I agree with what Jessica was saying, and I think Sue raised a really good point too, that there's this issue where people can be really left without recourse when they're harmed in this situation. And I understand what Russell was saying, that there could be room for change in SARA, and I think that if the federal regulation went forward as proposed, originally requiring more than just general application be preserved in SARA, then that would cause that change to SARA, and that would be I think a positive change for consumers.
To institutions that are degree granting and not in SARA, California, of course, any institution offering distance ed in California, we have a number of them, DEAC accredited, they go to all 49 states and they have 49 enrollment agreements. They make sure they have explicit disclosures by state, and they are just working through this one state at a time. They renew every year as they need to, and they've just built that into their apparatus. Many of them tell me they'd like to devote those resources to other things rather than constantly renewing and cycling through 49 state authorization processes if they're a distance ed institution. We don't think California is going to come into the SARA fold anytime soon, but it, I know, is a great cause for resources being used towards this that may be available to the institution in other ways.
Meredith.
I think I'm a strong believer that somehow we need to get SARA to the point that the states are comfortable with it and the schools know how to be a good actor. That I think that's, you know, for a lot of the schools, we're just looking to make sure we have our I's dotted, our students know what to expect, they know what their responsibilities are, and we know what ours are. Just a little context, Leah, and we have had, and we act in a way, it's not just the challenges on the states, and this is, I think, undermines why SARA is so important even to our non-degree offering. You can wait years to hear back from a state. So I think that's the other piece. If we want to stifle innovation, and I'm not exaggerating that. It can take years to hear back from these states for an institution trying to do the right thing. So I think we need to keep that, and you may have examples of that with your schools.
Amanda, I think the copies were all given to you to pass. No hoarding. Go ahead, Jody. Go ahead.
I just wanted to respond to Jillian. I think Leah brought up California institutions, but we also have had issues, and this gets into a really arcane technical area that involve the financial responsibility standards, which we have a whole fun report on this that goes into depth that I can circulate if you are interested. But the financial responsibility standards that are calculating whether a school is at risk of precipitous closure, Sarah has adopted those standards. And the problem is that we've been asking the department to make a fix to these financial responsibility standards for years. Currently, they are not compliant with, they are calculated based on, they're misclassifying assets, number one. So for example, if a school's endowment declines, that's counted as a loss against the institution. So we had a situation where one of our Ivy League schools was at risk of failing financial responsibility, even though they were not ever at risk of actually closing precipitously. We also, they also are not, the financial responsibility standards that the department is currently applying aren't consistent with federal accounting standards that nonprofits use to keep their books. So what's ended up, and the department, and Sarah is using a financial responsibility calculation with a lower threshold. So we have schools that have been kicked out of Sarah because even though they're not anywhere near at risk of closure, they're failing these financial responsibility standards that aren't properly calculated. So this is something that's been a really big issue for us.
Denise?
I just want to ask you a question. I keep doing that, sorry. So I have all the facts. Why are the non-degree programs exempt? Do you know?
I didn't say they were.
Oh.
You mean exempt from Sarah?
Sarah.
I mean, because Sarah is an agreement among the degree granting authorities for the states.
And there's no equivalent.
Because most states typically have a degree granting authority review and then a non-degree or career and technical review. So there's two levels. So the reciprocity is among the degree granting levels of the states and not the non-degree.
Okay, thank you.
Go ahead, Jillian.
So I have the same concerns, actually, that Jody expressed with respect to some of the financial responsibility composite score calculations and how that's affected some institutions and not others. But I think it brings to light this question of how, and I don't know the answer to this, so I'm just throwing it out there, how much oversight the department should have on a non-regulating body, which is what Sarah is. And I don't know, right? So I think there'd be benefit from some additional definition, but I don't know to the extent the department feels comfortable with that or even can do that, given that it's a sort of, I don't know, membership organization that's voluntary and sort of operates in its own atmosphere. I don't know the answer, but I think it's something worth considering as we sort of move forward with trying to figure out how to better write some of these definitions.
Yeah, I just wanted to respond to that. I think that that's also been one of our concerns is just there's not, because it is operating outside of the regulatory sphere, and I don't know what the answer is either, but it's not part of the structure of the Higher Education Act, and therefore it makes it very difficult to flesh out the relationship, and it's just, it's something that's totally outside of the norm, and we've kind of questioned whether Sarah should have such a, I mean, we want that reciprocity because it's so critical for our institutions, but at the same time, it's sort of weird to deal with this.
Go ahead. Yeah, go ahead.
I know the financial responsibility of 1.5 is fixed. And Sarah set that because they wanted to have a certain bar. If you go below 1.5, you're out. in financial aid eligibility, you can post a letter of credit and you're not in and out of financial aid the way you can be in and out of SARA. And I get that. There have been concerns brought to SARA about this. And I know that it's something that is being considered. And I realize that this process is not going to affect at all how SARA sets that standard. What I think would be helpful is if we had some suggestions of other ways to demonstrate financial responsibility that could be an acceptable alternative to that 1.5. But I just want to say that has been set because we want to treat the reciprocity with the highest level of assurance of financial responsibility across the spectrum of these distance schools.
Go ahead, respond.
I think we would have a lot less problem with that if the financial responsibility standards were actually being calculated on a rational metric, right? I mean, if it's not consistent with current accounting standards and the department hasn't fixed that, I mean, I'm sorry, I don't want to pick on the department, but this is something that has been such a huge source of frustration for our institutions and that we've been asking for years and years to get a fix from. So you're talking about something where you're asking the institutions to keep a completely inconsistent set of books, and and it's just nonsensical. So that's our issue. Yeah.
We brought John Coladas up, and he's our financial responsibility person, so he's going to address that matter. Thank you, John.
Okay. First off, some of the issues that you raised with the financial responsibility calculation, those issues were discussed in the Financial Responsibility Subcommittee for Borrower Defense. So if you read the preamble to the borrower defense rules, you would see that discussion and some of the changes that we proposed, including the endowments. So I think we recognize some of those concerns, and we had proposed at that point some corrections. We disagree with some of the arguments and presumptions about that we're otherwise not calculating the score in accordance with accounting standards. That's a matter of disagreement, but that's another discussion. But in any event, we made a lot of corrections, and assuming that we publish or republish another NPRM for borrower defense, you'll see those changes.
So, I mean, these haven't actually been implemented, though, despite these recommendations?
Correct. We're in the process now of redoing the borrower defense NPRM. But if you read the NPRM that we had published previously for borrower defense, there was a financial responsibility component, and you could see the changes that we had proposed in that NPRM.
Right. Our concern is that those haven't actually been implemented, and we're not sure where we stand on this.
Yeah, I was just addressing the fact that we did take steps to correct that.
Can we, go ahead with a couple more comments, and I think we want to maybe summarize where we're at this point, so that we can come back to it. But whoever wants to speak before that.
Go ahead, Jessica.
Thanks, John.
Sure. Someone over here asked a sort of broader question about like what is the relationship between ed and the states here, and I think from our perspective that as the states is an important part of the triad, it's always been consumer protection, and I think the reasoning that went into the 2016 rule is that ed needs to make sure states are doing a minimum amount of work there to like have it be real, meaningful state authorization, and to try and name things that are requirements that ed requires the states to do if they're going to authorize states. And I think sort of that's the conversation we're having is like what is like real, meaningful state authorization, and how does that impact students?
Sue.
Sue, do you have your microphone on?
I guess I don't.
You might want to start again because what you said was not picked up.
Okay, just the background on Sarah. I want to make sure we know 49 of the 50 states are now members, and we certainly wish California would be. But I want to give a pre and post. In the state of Iowa, we went to a lot of work with the gentleman who covers Iowa from SHIO, and we gathered what it was costing for each of the individual universities. Our 3 regents are independent nonprofits. Some of our other nonprofits that were having to go across state lines, so they saw great value in this. It was close to $1 million in the state of Iowa that we were adding on to the cost of education. So, you know, the point that Jessica made, and it's a good one. In some situations, it may be only equal to the cost of tuition. But when you're trying to send 3 students to a state and it's costing $16,000, in order to have that, is that fair to all of the students? So I think we've got a good model which we can ask for tweaks on, but let's not go back to the way it was where we had, you know, we're a small university. Some of our other independents, you know, they're small universities, our community colleges that sit right on a state border that are drawing students from across the state line. These are costs to education that then our students are having to pay through tuition.
Jessica. Oh, Robert, I'm sorry. I can't see your name. Can't call it.
Sorry. First, I want to second what Sue said. I really think that we've gained a lot through NC Sarah, our relationship there, and what's going on. My chancellors, you know, have worked very hard to help hammer out these agreements with their states, and I think we should build on that. That doesn't mean that there can't be tweaks, and we need to make sure that students are protected with some recourse when there have been violations here. But we can figure out some of those specifics. But also what Jessica hit on earlier, and I mentioned yesterday, I think we need to fundamentally rethink the triad and give it some true teeth and some avenues of partnership of what's expected by each entity of the triad, whether it be feds, state, or accreditors. I think it's a nice philosophical conversation on occasion. We talk about higher ed reauthorization and how this was fundamentally set up, but I think a lot of the paths that could be utilized have been broken, or with the development of the way things operate now, they just aren't as efficient and effective as they once were. And we do need, if a state is going to authorize, there does need to be some teeth there, and we need to figure out what is going to go into that process and what is, you know, what the feds are going to expect there. And we often talk in terms of a floor, and if we're going to do that there, let's have the floor start on the 10th floor. Let's have it be something that really means something, that really helps set a course here for us. So us as states and SHIOs, we're very open to this conversation. I run into a lot of frustrated SHIOs where we're dealing with institutions where there is going to be a precipitous closure, where they had no idea about this, and now they have to help with the teach out in some way because it's in code that they do that, but they've had no responsibility for that institution that's not within their public purview up until that point. And so we just have to figure out a way to get a lot of that on the same page, and I think this is a part of that conversation, but I just want to observe that it's fundamentally a much larger conversation too that this needs to be incorporated into.
And to that point, right now we're keeping the discussion a little bit narrower. While I definitely acknowledge the broader conversation is happening and it's a good conversation to have, we would be interested if you think there are certain things that need to be set in order for there to be a floor of requirements. Let us know. We'll take a look at it, and maybe we'll take a look at it at the next subcommittee session. All right,
Jessica.
Just real quick, I just want to be clear that I don't think anyone is well served by having huge time and expense in terms of startup costs. So when we're talking about shopping around the 50 states and all of these different expenses and it taking years, I think, you know, and so in terms of the expense, I understand that that's one piece. And then I think the piece that we might have different views on is sort of the ongoing compliance and monitoring, but I just want to be clear.
So I want to summarize a little bit of what I've heard and make sure that I've captured at least some of the conversation and like make sure that I catch everything. So I heard general support for the concept of reciprocity. There may be some differences regarding what's necessary and what kinds of rules need to be enforced, but the fact that it seems to reduce cost and reduce burdens for institutions who have distance education, I think there's general support for. I heard from Carolyn and Jessica that they support the part of the reciprocity definition that says that state laws, whether general or specifically directed at educational institutions, that's an important part of the definition because it allows states to have those requirements. But there are still concerns from other folks about states having laws that are burdensome, that cause institutions to have a 50-state database of information about the different things they have to comply with. So we'll think about how to square that as we come back next time. We also heard from Russ that it's important to change the concept of residence to location. And I think we heard at least most folks, if people have concerns about this, let us know. But we heard most folks think it was a good idea to ensure that that's addressed at the time of admission. And we heard concerns about lack of oversight, department oversight over SARA and some of the rules that they've set. That may have caused problems for institutions, or that, as others said, that may not set an adequate floor for oversight. Not clear right now if the department is able to do anything with SARA. We'll take it back. We'll think about it, and we'll come back maybe with some suggestions about what we can do, or we'll let you know that we don't, we're not sure what we can do in that space, but we'll think about it. Is there anything else that I haven't captured here? Okay. Yeah, so we heard you there. I know that Jody does have some schools in her constituency, and maybe that you could help with that.
Yeah, we can look into that. Thanks.
All right, thanks. So with that, I'd like to go to a different section, disclosures. It's 34 CFR 668.50, and I'm going to have to dig that up as well. That's the other part of the regulation from 2016 that relates to disclosures for schools that are offering distance ed or correspondence courses in which students are 100% distance ed or correspondence.
It's page 41. Yep.
Sounds good. Yep. All right, and as people are getting to it, I'll give a brief summary of what is in this part of the regulations. These regulations were created again in 2016. They are directed at institutions offering programs in which students are 100% enrolled in distance education or correspondence courses. It creates this time I'm not going to go through every single one of the regulations, but we can talk about them as we go through. It creates two different sets of disclosures that institutions are required to make to students. One of the two types is public disclosures. Schools must make a number of public disclosures on its website, including whether the institution is authorized by each state in which the students are residing. A lot of information about the consequences if students move between places, description of consumer complaint requirements, adverse actions that states or accreditors have initiated against the institution, the sorts of things that the school would have to disclose to anyone who was looking at their website. Then there was a second category of disclosures that were individualized, that needed to go to students who were needed to go to prospective students, and in some cases to enrolled students. To prospective students, it would have required that anytime the institution determined that it did not meet licensure or certification prerequisites in a state in which one of the students lived, they'd have to tell the student specifically. And then to each enrolled and prospective student, they would have to disclose adverse actions that the state had initiated or an accrediting agency had initiated. And they also had to tell schools that anytime that they ceased to meet licensure or certification prerequisites. So there's a lot there, but I wanted to start out by saying that the department's initial position is that all of these disclosures would be removed, and that we wouldn't have this section would essentially be eliminated. Like I said before, we're interested in the things that folks around the table think are the most important about these, and we're especially interested in conversation about the topic of licensure, and especially in cases where the institution is aware that its program doesn't meet licensure requirements in a state. We think that's a particularly problematic issue, and we want to think about how to address it. So I'll stop there.
I think before we go into discussion, we'll take a break now. Is that all right, Greg? Or do you want to go into discussion?
Folks want to just take a break and think about this, and we can come back in a few minutes.
That might be a good idea. 15.
Okay. Let's just say 17 after.
I want that to be 18 after, Tony. I'm sorry. Yes.
I'm sorry. I'm gone Greenwich time. point out that Greg Martin's the only person that can stop the clocks here. He's like the queen.
I just want to make a grand entrance for the camera. You know, I thought that was important.
All right, so yeah, let's pick up our discussion on the disclosures one more time. So I went through a very brief overview of what our disclosures are required related to distance education and correspondence courses. So I'd like to open it up to the group to discuss, again, things that that you think are important in those regulations, things that you think need to be changed, or things that you think should be removed.
Okay. So I have a forest here, and I think I. Okay, so we'll start with Caroline.
Just wanted to indicate that I think that these disclosures in general are very important and useful for protecting consumers who are not necessarily that sophisticated, might not understand that there are issues that they may not even be aware of related specifically to licensure in different states. Some of the students that we see, it would not even necessarily occur to them that there could be an issue because they just assume that if they're taking a course in their state, then that course would lead to licensure in their state. So I think that especially the disclosures related to licensure are particularly important, but I think that all of the ones here have been sort of well crafted to address specific issues that face consumers in this space.
All right, and Jillian.
Thanks. So I have a few comments. So in general, I would say, and I'm sure the department doesn't disagree with this, it'd be great in general if we could have sort of a coordinated effort with respect to disclosures to students. And I'm talking about broader than just this rulemaking, right? So we know that there are disclosure requirements in several that sort of touch on several things, gainful employment, other things. In general, it would be great if we have sort of a consolidated approach towards disclosure. So I think we all philosophically probably agree with that, but I just want to put it out there. And related to that, would really encourage the department to consumer test disclosures before sort of landing finally on what they believe is most important, because I think consumers can best tell us, the students can best tell us what is important to them and what isn't important, and in an effort to make sure we're getting the most important information in front of students, I think it's really important that we don't sort of overwhelm them with information that is not as pertinent to their decision-making process. With respect to the languages that's written here, so, a couple of nitty things. There's reside is still in here, so to the extent that we're cleaning up sort of reside in other places, I would encourage the same perspective in this work that it's prior to enrollment. And then the term adverse action is also in here without, to my understanding, a definition. I think there's one with respect to accreditation perhaps, but talks about adverse action a state has initiated. I don't exactly know what that means, and I think there's a risk that every institution will choose to interpret that differently, right? So again, to the extent that we're interested in seeing if these are things that resonate with students, let's just make sure that we're taking a consistent approach towards how we're talking about them and defining these terms so that institutions can be, so that students can see sort of apples to apples information. And then with respect to licensure, so I think I mentioned this yesterday, Capella University has many programs that lead to licensure, and we're strongly in favor of leaving in a disclosure requirement with respect to these programs. We think it's crazy that a student would be able to be enrolled in one of these programs in a state and not even know if they're going to be able to sit for a licensing test to get a job. The one thing I would say is we would just recommend a little bit of clarity around the term licensure program, which I don't want to complicate things, but I think some institutions are confused about if you can be a real estate agent, for example, in a state by having a bachelor's degree, does that make every bachelor's degree program at your institution a licensure track program? I think we know that's not the intention, but I think there are some institutions that are confused about the definition of that. So my proposal would be something like programs advertised as meeting educational requirements for a specific professional license or certification that is required for employment in that field. And I can send that to you, but just to be super clear about what sorts of programs that we're talking about so that schools don't feel like they either can get out of the requirement if they're legitimately offering licensure track programs, or schools that aren't actually offering licensure track programs aren't sort of conflating the issue. I think those are all my comments for now.
Okay. Leah.
So I'd kind of like to address the same three topics Jillian did, just with my perspective on the disclosures in the area of complaints, adverse action, and licensure. I think we should have one kind of consolidated idea about the complaint disclosure process. Can we make this a little bit more streamlined, but that it's clear to students in 100% distance ed programs what their avenues are in terms of filing a complaint. With respect to disclosure of adverse actions going back 5 years, I'm just not sure what that does to move the needle for students. Existing adverse actions, like subject to right now, I think are important to be made clear to students. And I think that perhaps there is for distance ed students and distance ed participating institutions, making that clear could be of benefit. And then lastly, with regard to licensure in occupations that lead to an examination, again, if we are enrolling students in program, for a profession of a lifetime, I mean, the time is now at the time of enrollment and going through the course of study to understand how you're going to navigate that licensure process. And I think the institution should, by all means, be sharing with students by state what that process is. And maybe not just distance ed. I mean, maybe for any type of licensing situation, whether you're a residence-based campus, enrolling students from all over the U.S. that are going to go back to their home state and take an exam and practice in their field. I mean, maybe this is something that we should look at as a disclosure across the spectrum of higher ed and not just focused on 100% online institutions.
Thank you. Russell.
Thank you. I'm going to repeat letters that I write to David and your friends. But I'm falling in line with the others in terms of the really around the complaints and the professional licensure. That those are issues that really have to be in here. I've heard some just really bad stories about institutions of all types. It actually took me like 3 years before I had a complaint about a for-profit institution. Most of them were about nonprofits or state institutions that were not doing well in the professional licensure, and I think that's something that we need to step up on. For the others, that I think there are several areas in terms of if you keep them, just whether it's here or in subsequent guidance, that there were clarifications that we sought in there's the paragraph about consequences. I sort of get what you want to do, but we were very puzzled about what does that look like in practice. Refund policies was another one where we had several people read different things, and so the particular was like for a SARA institution operating in a state under SARA, does it report the refund policy it uses as part of SARA or the state's refund policy? And I thought I understood it, but I had some really smart people who said you would report both, which wouldn't help the student if you're giving them the wrong refund policy, right? That doesn't apply. Adverse actions, that's been brought up, and we talked to some accreditors in some states, and they used different terms for that in different levels, and so it was, okay, how do we apply that across? So there's all sorts of, there's things like that. And then the last thing that I have here is that is about the solely through distance education thing, that needs to be defined, and where do hybrid programs fit into that, because it seems like it, from a consumer protection standpoint, it could end up being a real hole that you could drive a truck through, that it'd be really easy for programs just to do a little bit face-to-face in order to get around some of these things. And what do you do about the programs that were mentioned yesterday, where it really is, most of it is done at a distance, but there is some sort of practical part of it, and where is the dividing line for those? And so need some more clarification on that. So thank you.
Russell. David.
So I just want to support what Russ and Leah said, and especially Leah's point that this shouldn't be just a distance ed issue. I mean, institutions, I think, have a responsibility to help their students understand how licensure works in those disciplines where licenses are important, right? So that's got to be part of the education process. I do think, though, that there is a point of the disclosure piece where the institution's responsibility needs to end and it needs to shift onto the student, and that is if the student starts to move around. So just like when we were talking about state reciprocity agreements, the same should hold here, where at the point of admission, the student clearly needs to understand what the implications are for licensure. But then if the student decides to move to 2 other states over the course of her studies, that shouldn't be on the institution to chase the student.
Jody.
Yeah, I just wanted to sort of make a general comment to reiterate what I said last night, which is that we've generally been supportive of repealing these disclosures, and I'm coming from again the nonprofit perspective, private nonprofit perspective, which is that these have been extremely burdensome. Again, a lot of this has required tiny institutions to hire multiple staff to track. I mean, it's these things are incredibly difficult to track, constantly changing state licensure requirements, to constantly monitor, adverse act. It's too much, and so I'll leave it at that. But I mean, we're definitely open to hearing arguments about why certain pieces of this should be retained.
Jessica.
Thank you. Again, just to go back to what this might look like on the ground, one of the huge problems in fraudulent schools obviously is oral misrepresentations, and I think some of the written disclosure requirements are directed at trying to contradict the oral misrepresentation. So we have a student who went into an office in like a school to enroll in like a technical medical field that requires licensure. She said, is the program accredited? They pointed at the wall with a certificate and said, yeah, it's accredited, without obviously going into what that accreditation was and whether that accreditation was sufficient for licensure. It wasn't. She has, something like $45,000 of student loan debt and has had her borrower defense application sitting with the department for 3 years and 10 months, I believe. So, I think this only works if students actually can understand what it is. So I think from like a legal aid perspective, we want simplified disclosures. We want disclosures that are relevant to students. We don't want, the kitchen sink of 150 things that no one's going to read and it's not real. Fewer, clearer, at a reading level students understand that just says, something like, this program can lead to licensure in this state and not other states, or something. I don't want to put words in your mouth, but something like that. I think we just want a way to be very clear to students before they get into the process about what they can get out of it.
Denise?
Jessica, just to follow up on that. So we heard from other people what they think are the most important. From your perspective, and I guess from Amanda's, if we're going to look at this, what are the areas that you as a student advocate and you as a student think are the most important for disclosures? I think that's important to have on the table.
Sure, absolutely the licensure issue, and I hear you that it's a bigger than distance ed, but I think it is disproportionately an issue in distance ed because of just people cross state lines way more. We would put a complaint, a clear complaint process of who you can go to for help. And I think the adverse action thing is hard, and I hear the definition, but I think students, we hear over and over, which is if everyone knew the school was bad, why didn't anybody tell me? And I think that we need to, when it shuts down or whatever, they lose their ability for Title IV. So think about a way to communicate what knowledge is in your head and in my head to students who are making an informed choice.
Jillian.
So a couple thoughts. One, and I'm just sort of brainstorming a little bit here, but I think, David, to your comment, perhaps there's language that's added in that initial disclosure that goes to students that says, this represents where you live today. it's sort of on you to reach out to us, and please do that if you move, and we'll be happy to tell you what your state-specific licensure status looks like. I think, the licensure disclosure can't turn into like a game of gotcha to institutions, which I think it runs that risk if we say you should be able to track students and figure out where they're living and notify them within 14 days is a little bit unreasonable, and it really sets schools up for probably unnecessary litigation that even if the school's trying to do the best thing, it ends up being sort of a terrible thing. Jody, to your comment, again, just sort of brainstorming, I don't know if it makes sense to think about like if there's a number threshold in terms of like if you enroll over X number of students from a particular state in this licensure program, then you have an obligation. I don't know. I'm just trying to think creatively about sort of how we balance sort of the cost of doing all of this that I'm sure would end up getting passed along to students anyway, which none of us want, with sort of this need to really be transparent, or I don't know. So open to other creative solutions there.
Jody, go ahead. No? Oh, it's Amanda. I'm sorry.
So I really appreciate that this is a requirement, just disclosure agreements in general as a concept. I think that students in the higher ed world, before even enrolling, while you're enrolled, and then after you're enrolled, there's all these information asymmetry problems. So I think this is a way to solve that policy problem just in the higher ed sector across the board, but specifically when we narrow down back to online programs, knowing the students who are in these programs are low income. I'm a first generation college student. I did a traditional 4-year college. But just even before, there's a ton of information that was not presented to me. I had to look for it, couldn't find it, didn't know where to go. I think if the institution or just we had a world where information was more available to students in a way that Jessica described. So just knowing that from my personal experience and others as well, even then going back again to online programs where it is more accessible, I think that's great. And I think probably the most winnable piece, or the piece that I think is really important because it's tied to, we go to these programs to be employed, to have financial stability for the rest of our lives. And so I think that anything that touches labor, employment, or the security of that should be informed to students. So I know that's kind of broad, but if you just kind of think about that in the back of your head, like, this is really important, this is the point. So I think licensure information are things that are not coherent, or if the program is not doing it before 5 years before, it gives a student an understanding of like the probability that they will or will not come out of employment. So I would say that's probably a very important part if that's the majority of what these programs are providing to students. But anything that's related to hindering their employment, I think is still relevant and important. And I understand that it could be a lot of work on institutions, but I think that's something the institutions should do as a requirement, as a minimum.
Go ahead, David. David, go ahead. You're
Sorry. Just briefly in response to Jody, at some point I think, to students, the thing that's most important is to say they know that they're going in, that it might not get what they want. And so I think from the legal aid perspective, at some point in the prior rulemaking, there was some proposal, no one likes handwriting in distance ed, but a proposal that basically in the student's own handwriting says, I live in California, I understand, and the school has told me that even if I take this program, I might not be able to become a whatever, cosmetologist or whatever in California, which, I think it gets a little bit at what you were talking about.
Yeah, I just wanted to also say that to echo people's comments about sort of the overwhelming nature of disclosures in some cases, this is something that we've actually, it's a longer story, but we at one point convened a focus group, for example, to ask students what were the most important disclosure requirements, and created a system that that sort of is like scorecard, but with lots more points on it, that students can look, and so we're interested in knowing what exactly students would find the most helpful without overwhelming them with information, so much information that it all just goes in one ear or one eye and out the other.
David, go ahead.
No, I'd like to thank everybody for their comments about this. They've given us plenty to think about. So I think what we're going to do on this topic is take it back. We're going to need to have some conversations among all of our leadership and all of our policy folks. We're going to come back next session with some proposals, and then maybe we can work with you guys to narrow them, change them, get them as close to what you guys think is the right path as we can. With that, I think I'd like to turn it over to Greg so that we can move on to other issues in Part 600.
Thanks, David, and I thank all of you for that discussion. It was very useful. What I would like to do now is just do some cleanup, some things I think are a little more minor, finish out definitions. We're trying to get to the discussion of written agreements later this afternoon, which I think will be something that will probably prompt a great deal of discussion. So trying to get through these as quickly as possible. So the first one I want to look at is the definition of an incarcerated student. And you'll find that in 600.2. And it's a pretty minor change here. You'll see that all we did was in looking at who is considered to be an incarcerated student, we have added youth correctional facility. After prison, jail, reformatory, work farm, youth correctional facility, or other similar correctional institution. That's just a clarification that a youth correctional facility is, in fact, a prison. So, I'm sorry, 4, page 4. So I'll just give you a chance to read over that. I don't have anything else to say about it other than it is a clarification. If anybody has any comments, I'd be willing to entertain that.
Is this going to newly exclude a whole class of people from Title IV?
Pardon? I'm sorry.
Sure. Is the import of this change to newly exclude a whole group of people from Title IV?
No, the point of this change is not to exclude people. The law is fairly clear on what types of facilities you have to be incarcerated in to not be eligible for a Pell Grant. This would not change that definition.
So it's just like a codification of what you're already doing?
It has to do with the percentage of incarcerated students a school can have, right?
The policy already, it's the way it's been applied already. They're just putting it in there to make it clear.
It's absolutely no change in our policy.
Yeah, the important point is the students who are prohibited from receiving Pell Grant funds are those who are incarcerated in federal and state penal institutions. This would never qualify This change has no effect on that part of the provision. This is, again, as Greg said, just about the percentage of students who are incarcerated, which is a different requirement.
Do we have any comments on that? Any more comments on that? Okay. Okay, the next, we're taking that bottle away from Denise permanently.
Yeah.
She's an excellent attorney, but her coke drinking skills.
Clean up on 05.
There's something to be desired. Just water for you. Cutting her off. Okay, so the next one is the definition of a nonprofit institution. So you'll find that on page 5. It's also under 600.2. And looking at the change there, you'll see that we have stricken is determined by the U.S. Internal Revenue Service to be an organization which contributes. And by the way, I should add, is determined by the U.S. Internal Revenue Service to be an organization which contributes a tax to which contributions are tax deductible in accordance with 501c3.
Caroline?
I just didn't understand the background for that change.
It's it's simply that we're for the definition of what we consider to be a nonprofit organization, a nonprofit entity. We're not going to look at the tax code definition of that as being for charitable contributions.
As solely the only factor to look at. That it's going to, the department's making making a determination based on a number of factors. That's because before, I think a lot of the understanding was that was the only thing that we looked at. So we have actually a group that looks at the conversions from profit to nonprofit, and they just wanted to make clear that we're making a call. It's not just if you're not considered nonprofit for our purposes just because the IRS considers you nonprofit.
Okay, if I can respond, in that case, I think that's a positive change because we certainly are aware of an issue where some for-profit colleges who are not necessarily the good actors have tried to sort of shield themselves from scrutiny and from regulation by converting to nonprofit in some ways, but not always. And so I think that would be a helpful change.
Yeah, for people who may be confused, I wanted to confirm this, but it looks like in definition in 1 Romanet 3, you have 3 factors, one of which includes the charitable, same exact charitable language that is in paragraph 3. So, yes, okay.
When it was listed as a 3, I think there was the opinion it looked like it was the sole factor. If you were that, then you automatically are going to become it versus it being one of the factors that the department considers.
Right. Okay, yeah, we support that as well. Thank you.
Okay, the next one we're going to look at is, I'm sorry, do we have another comment?
Jillian.
So back to your comment about sort of striking this in order to show that the department will be doing its own analysis. I think that's what I understood you saying in terms of.
It's listed as one of the factors that we consider, but I think there was a confusion that was a sole factor.
Yeah, I guess I just want to, which I don't think is what you're saying, but I just want to confirm that it will be clear to institutions that are interested in converting to nonprofit status exactly what that means and what criterion the department is using. So I just want to, I think maybe I heard
right, and
that
I
you
think
weren't
that there is a group working on that area. It's not mine area of expertise, but I do believe they may be getting things out, but they're working through that process right now in terms of what factors they're considering. So I will take that back.
Yeah, I would just say it's in
for the community to understand.
Everybody's best interest that it's clear
right.
to institutions on behalf of students, sort of everybody, so that.
Right. I'll take that back and make sure it's considered to get something out so that they understand.
Jody, did you have a comment?
Okay, the next definition we're going to move on to is teach out. It's on page 7. Give you a moment to get there.
Just real quick, in case you guys are wondering, there is a definition of religious mission that is here, and we're not going to address that. That's going to be addressed by the faith-based subcommittee.
So you'll see first off the addition of a definition of teach out, and we've always had the concept of teach out, and we had a definition of a teach out plan, but I think what we have here is expanding on that and clarifying what's occurring in a teach out situation. The first thing being the definition of a teach out, which you can see there, which is new, and a period of time during which a program, institution, or institutional location that provides 100% of at least one program offered engages in an orderly closure, or when following a closure of an institution or campus, another institution provides an opportunity for the students of the closed school to complete their program. So just describing what a teach out is. We then break out, as you see there, we previously had, we now have the definition of a teach out plan. We are adding a teach out agreement as to differentiate between the plan and the agreement. So as you can see there in the definition of an agreement, the agreement is between institutions that provide for the equitable treatment of students and a reasonable opportunity for students to complete their program of study if an institution or institutional location that provides 100% of at least one program ceases to operate or plans to cease operations before all enrolled students have completed their program of study. and the creditor is permitted to waive requirements regarding the percentage of credits which must be earned by a student at the institution awarding a degree or certification when a student is completing his or her program through a written teach-out agreement. So the agreement is something that would be in place already between entities, and so we're making a distinction there between that and what you see below, the current definition of a teach-out plan. The plan is so there's the agreement between two institutions, and then there's the plan, which is the plan that an institution has in place as to what will happen in the event of a closure. So the plan is developed by an institution that provides for the equitable treatment of students if an institution or institutional location that provides 100% of at least one program ceases to operate, and we've added here, or plans to cease operation before all enrolled students have completed their program. So that the two really are different. The school has a plan in place for a teach-out, and then has could have an agreement between itself and another entity. Any comments, questions?
We start with Jessica.
Sorry, I wasn't expecting that one. Do we want to go in? I mean, this is a huge deal to the extent that it impacts Title IV availability for during the teach-out closure process. Do you want to hold off on those comments? I mean, obviously that the definition and then the later actual reg are related here.
Yeah, we'll talk it through, and if you want to refer to the other section, we can do that as well.
Sure. Could you? I just know the big picture in my head. Could you point me to the site?
Give us a moment. Right. I think there are references in the program participation agreement in 668.14. There's also in the accreditation. I would probably want to bring back Beth if we're going to have a discussion about that as references the accreditation rules.
Were your comments related to that accreditation piece? Or we could just go over them generally if you want to go ahead and get them on the record.
Thank
and
you.
then we can see if we need to bring Beth in.
Thank you. My understanding is this is a significant change in that essentially it allows a closing school to operate, continuing to use Title IV funds in this like quasi-closed role as a teach-out because it adds the school's own instruction to the teach-out and then allows the use of Title IV funds for 120 days. Is that right?
We'll take about 2 minutes here. Hold on.
Yeah, Jessica, if you could just let us know exactly what your concerns are, discussion is, because in terms of, I guess the way the department has always processed it, we have allowed teach-outs at an institution that's closing, and they can continue to, as long as they continue to provide education, they're entitled to funds to the end of the payment period under another regulation, 668.26. So if you think it's a change in that, there isn't, because that's occurred before. So I'm just trying to figure out what you.
Sure. I'm sorry it took me a while.
Oh, you're fine.
It's 641, termination and emergency action proceedings, adds a new subsection D24 that after termination of the I'm summarizing. Sure. 31 on the same packet. So after termination of the eligibility of an institution, essentially, I read this to say that the institution can still receive Title IV funds for up to 120 days of their own teach-out plan as approved by the accreditor. And I guess my big picture concerns, and maybe I'm misreading these terms, is that how this interacts with closed school discharge. So, like I said yesterday, I think closed school discharge is incredibly important for people whose schools closed, and often staying in the schools doesn't serve them well, and 120 extra days at the same school isn't really getting them anywhere. And so my concerns are in this language, if I'm understanding it right, which is totally possible I'm not, that we would, that students would lose the right to closed school discharge because closed school discharge also has a 120-day period as it currently stands.
Okay, I'm going to have to be honest with you. I'm going to have to look at this provision because I don't recall looking at it before. Not going to say I didn't, but there's, as you know, there's a stack of things we were looking at. But the discharge provisions apply when a student can't complete their program. Even if they finish that payment period, that doesn't necessarily mean they're going to complete their program. Right? So your concern here, then I want to make sure we're looking at it correctly, is you want to make sure that that provision does not prohibit students from getting a closed school discharge. That's your concern?
Exactly. I know that there was, in the proposed borrower defense rule, there's a proposal that if a teach out is even offered, closed school discharge would come off the table, which is like a separate thing. But I'm imagining in the world in which the student has the option to take a teach out or take the closed school discharge, that this, because of the 120-day period, students would stay automatically enrolled for the same 120 days as in closed school discharge and would essentially lose their closed school discharge rights without having any idea that they had them in the first place.
So this one I probably can look at with my colleagues at lunchtime and get back to you what exactly that provision was intended to address.
Thank you. I didn't mean to derail the conversation.
No, that's okay.
Thank you.
No, you're fine.
Leah?
Under the teach-out agreement definition, I wanted to suggest that this include approval by the state, the accreditor, and the Department of Ed in executing the teach-out agreement. So a teach-out agreement is effective when the accreditor has approved the arrangement, the state has approved the arrangement, and the Department of Ed has said, yes, the Title IV access can continue in this arrangement. And I think it could be helpful if this definition includes that provision. I mean, you can have a teach-out agreement between two entities, but if it hasn't received formal approval, I think, by the accreditor, and sometimes two accreditors, if it's crossing, two accreditors, one accreditor has a school that's closing, one accreditor has a school that'll handle the teach out of the students. Getting approvals through those circles as well as with the state involved and the Department of Ed, I think makes for a more secure situation for the student.
Okay, so you're proposing that we add the department as an approving body on teach out agreements, which we've always said that we don't formally do.
In past experience working with closing schools, I have had interactions with the financial aid case team, that has engaged them on, hey, we have a group of students, a couple hundred, the school is closing, this school is coming in to do the teach out, or they're going to move over. Do we have assurances that the financial aid is going to keep going under this arrangement? And so I don't want to step outside the boundaries. I'm just thinking about something that's more secure for the student.
Okay, because we do typically, the department does that, and then over the last number of years where we've had so many more precipitous closures of larger institutions, we've got a whole team, as you know, that goes in, and the case teams in the regions do get actively involved in trying to assist. I think the department's position always has been the agreements between the entities, and we don't approve. So I just want to know I'm not saying we can't take it back to C, but if you think it would be something that you'd like to see in here, I can see if that.
I don't know that negotiating teach-out agreements is widely understood how to get that done by accreditors, maybe even by the states. I don't want to speak for states, but maybe, Robert, you can weigh in. I just think that this has been a matter that we've seen so many students affected by precipitous closure. Can we find a way to formalize that these parties get together in some form when we see something happening under potential closure, that we can work this out? That's all.
Okay, thank you.
David? I'm sorry.
Thanks. I was just actually looking for clarification on what the second sentence in the teach-out agreement means. I'm not sure how to read that.
So sometimes students have less than 25% left, like they may have one course or two courses left. Typically, accreditors don't allow more than 75% transfer of credit. And so what I've seen happen is the accreditors say, okay, you can go ahead and, two courses and award the degree for the closing school or for your institution.
So it's a transfer thing, not a waiving of requirements.
Typically, it's transfer of the credit. So you're allowing students to bring all but their 3 courses to the school offering the teach out, and you're allowing that degree to be conferred. And again, helpful to have the state involved with that as well.
Russell?
Thank you. Just a couple questions. One about the 100%, and then why is it at 100%? And then the second one is that would this cover any new provisions that if an institution were to completely outsource a program as is being proposed elsewhere, is that covered in this as well in terms of the teach out? So I'm an institution, I outsource it, and that would be a teach out as well?
You're talking about written arrangements, right? Commonly we.
So you want to understand the between that and the okay, I'm sorry.
So you want to what?
Why do we have 100% in here? Is your first question.
We'll take that back at lunch and discuss that. How that you're talking about how that would relate to a program where where a substantial portion of that program was being provided by another entity under a written agreement.
That's my second question.
No, but I want to confirm. So are you also asking? Let's say that a school offers 85% of a program at a location, and why? Number one, why does this not apply to that location, and what would happen? In that
right. Yeah,
location?
because you've now thankfully defined additional locations somewhere, and so that's at a 50% level.
Right. Whereas this says 100%.
This says 100%. Yep. And I could see where you're off somewhere.
We can take that back and take a look.
Jessica.
Thank you. I just wanted to follow up and support what Leah said. We have a institution that precipitously closed, and we have a teach out, which Middle State says isn't a teach out, which is ad posted in the closed school monthly report as having teach out schools, and the institution is just gone. And so, even as advocates, I can't figure out, is it a teach out, is it not a teach out? So I think there's a real need for that. And just to clarify, these definitions for teach out plan and teach out agreement exist in the current regs, but just in the accreditation section, it looks like they've been moved. And so some of this language was already there on page 5 of the 602 packet. If I'm reading this correctly, it looks like there's pretty similar definitions already in there, right?
So
I just mean that
right.
They're not coming up from scratch.
Most of these definitions are not being created from scratch. Most of them were moved from the 602 regulations in an attempt to move things that applied to more than one section to Part 600. There have been some changes, however, and that's part of what we're discussing.
Jillian.
Did you say you don't want to talk about the accreditation section right now with respect to Teach Out?
We can take comments on it if you like. We don't have our accreditation expert Beth with us today. If we need to bring someone else down from accreditation, we can. So we definitely can.
I mean,
can
I
take
can
the
I just
comments.
have one maybe simple comment, and I can definitely bring it up in the full committee too. But on the top of page 25 of the accreditation section, where it talks about while an online option may be made available to students enrolled in a closing ground-based program, such an option is not sufficient unless ground-based options are also provided. I guess I would just, I think we're all have the same interests in mind, which is making sure students have every option to complete their program. So I guess I would question this provision given sort of the current state of higher education and how so much is online, allowing potentially for an option for an institution to offer an online option and not precluding that here. So I can bring it up in the larger group too. I think there are some other folks on the full committee who also have concerns about it, but just wanted to mention that has a Teach Out tie-in.
Yeah, we'll hold on to that, but it probably would be best to bring up in the main committee discussion on accreditation.
David.
I just want to go back to what I think Russ was asking, and that is if an institution outsources a program and the outsourced provider goes belly up, what happens?
I think first of all we need to. I'm going to clarify some terms here. I don't look at what's being done under 668.5 as outsourcing. I think we need to keep it in context that it's a written arrangement with what traditional schools call consortium arrangements, where you are students taking coursework at another institution, and you are agreeing to accept that coursework back for credit at your own institution as if it were taken at your own school. So I don't know that I think outsource is necessarily a good word for that. So is your question if the other entity, be it eligible or ineligible, where the student is taking other coursework, goes out of existence, what does that do?
What I'm asking is, so there is also a proposal, if I understand this right, to allow institutions to partner with unaccredited providers, right? So that's what I'm calling outsourcing.
Yeah. So I can speak a little bit to this, though I do think it is something that we'll have to look at in the language. But my understanding is that the language that's proposed here anticipates a case where part of the program was provided through a written arrangement. What this says here is that if a program or a location closes, regardless of who's offering it, then a teach out, this definition applies. So this language is not sort of exempting cases where part of the program is offered through a written arrangement, and it's not, at least that's not the intention. But in looking at the language, I can see where that a concern may arise there, and so we may need to go back and look at the language there.
And I would point out that even in the case of where part of a program is being offered through a written arrangement, that it's still the entity. It's still that school's program, and that is I think that's what Dave was trying to say. It remains that institution's program and that institution's responsibility, irrespective of whether there is a written arrangement in place with an eligible or an ineligible entity.
Yes, but just again back to that point, in the proposed, we haven't gotten there yet, but in the proposed written arrangement regulations, we specifically have language that says "provided by," which appears to be mimicked here. And if it were treated in the same way, I can see where the concern comes up. So we'll take this back, and we may have to make some adjustments to this. But again, it's my understanding that was not the intent. We don't intend to exempt those cases. The teach out when a program shuts down, when a location shuts down, and students are in a position where they can't finish those things, this applies. That's what a teach out is, and that doesn't matter whether you're in a written arrangement or not, and we'll find a way to address it.
Yeah, so thank you for looking at that. My concern is that, let's imagine it's a small institution, outsources a good part of the program or all of a program, whoever's providing that outsourced instruction goes belly up. It may be fine to say, yeah, but the institution where the student is enrolled is still responsible, but that institution is now not in a position to respond.
And if in the situation you described, the student was unable to continue in the program, either at that institution or in some other capacity, then that's, again, a case where a teach-out may be the appropriate mechanism. So again, the definition is supposed to apply to those cases, and we'll find a way to make sure that it does. Yeah, I think so. We're going to take back a few things that we can maybe talk about after lunch on this topic, but I think we'd like to move on to some other things to get through before that point.
Okay, we're going to move on to 600.30. Should we do this first? All right. Before we move on to ownership, we'll this isn't necessarily on your agenda, but we have to look at definition of an institution, of different types of institutions in Part 600. So the first thing we'll look at is 600.4. The institution, an institution of higher education. It's not in the definitions. It's got its own section there. 600.4 on page 8. You'll note the only change if you turn over to page 9 and looking at what is what is considered to be an institution of higher education. On page 9, you'll see in C, the Secretary does not recognize the accreditation of or pre-accreditation of an institution unless the institution agrees to submit any dispute involving an adverse action such as the final denial, withdrawal, or termination of accreditation to initial arbitration before initiating any other legal action. So what this is doing here is this is an existing regulation. The pre-accreditation is already there. It's required by statute and reflected here in the regulation. We've adding an adverse action, and the definition of adverse action is actually found in 600.2. So we could go there under accreditation and look up. I'm sorry, not 600.2. Part 602. My mistake. Under definitions, and adverse action is found at the top of page 2. So you'll note that basically what's happening here with the addition of adverse action is that it kind of expands what was currently in 600.4. The denial, withdrawal, suspension, revocation, or termination of accreditation or pre-accreditation or any comparable accrediting action an agency may take against an institution. So it's adding, just sort of adding to that or making certain that that's included to, for instance, the final denial, withdrawal, termination. So right now the regulation pretty much mirrors exactly what's in statute, and then we're adding adverse action to it. We're doing the same thing in 600.5 under the definition of a proprietary institution of higher education. We do the same thing in 600.6 under the definition of a post-secondary vocational institution. So all those types of controls we have added an adverse action to. I should also point out that the requirement for pre-dispute arbitration is also in 668.14 as well. Any questions or comments? Oh, hold on a second. Oh, okay. I'll do that later. I'll do that when we get to this issue. Any comments on that? Okay, I also then, another change we have under 600.5 at the bottom of page 10 in E. So the current rule is, for purposes of this section, a program leading to a baccalaureate degree in liberal arts is a program that the institution's recognized regional accreditation agency or organization determines is a general instruction program in the liberal arts, the humanities disciplines, or the general curriculum falling within one or more of the following generally accepted instructional categories comprising such programs, but including only instruction in regular programs and excluding independently designed individualized programs and unstructured studies. And I won't read the entire definition there. It goes on to page 11. But what we've done here is stricken the portion of this that references is a program that the institution's recognized regional accreditation agency or organization determines is a general instructional program.
Jody?
Yeah, I was just wondering what the purpose of this change was.
So, well, let me start out with some context as to what this change affects. So if you scroll up just a little, if you look a little bit above, I'm the only one with a computer over here. If you look a little bit above, you'll see that the concept of a baccalaureate in liberal arts applies very narrowly to proprietary institutions, and it's a specific statutory carve-out for a very specific set of programs that are eligible programs, even though they don't lead to gainful employment in a recognized occupation, as all other programs that proprietary institutions are required to do. So it is a statutory requirement, and the statutory language is broader than what's in the definition currently. So what the department is doing here is simply making some simplifying changes to the definition that's in the regulation, keeping in mind that the statutory requirement and the statutory carve-out is in place regardless of what we do here.
Amanda?
Sorry, I just wanted to go back to just a general comment that I was, after reading the section D in 600.5 for D, the secretary does not recognize the accreditation of an institution unless the institution agrees to submit any disclosure or dispute involving an adverse action, such as the final denial, withdrawal, or termination of accreditation to initial arbitration. Just as a point for arbitration, my brain started working. I'm not sure if the arbitration is made public to students. I guess I was just thinking back to disclosure and making sure it's public to students or just the general public, what the results are. If the Department of Ed requires this as a floor.
Well, first of all, I want to point out this is a statutory, not the adverse action being added is not statutory, but the requirement you see there, if you took out what we're adding, it comes from statute. So the requirement for an this has to do with the institution. This has nothing to do with pre-arbitration or pre-dispute arbitration agreements with students, between students and institutions. It's got nothing to do with that. It has everything to do with the fact that with an institution's relationship with an accreditor, so that before the institution, which has one of these an adverse action, or the accreditor takes an action such as denial, withdrawal, or termination, before the institution who's subject to that action can take any additional legal has any additional legal recourse, they have to agree to initial arbitration. So that's part. So when the institution signs its enrollment agreement to participate with us, it's a contract. They're signing that they will consent to this. As far as help how public that would be if that occurred, I'll turn that over. I'll ask that of my accreditation people to see how public that would be.
Well, the recognition criteria require accreditors to make public any adverse action or sanction such along the lines of probation. So it would be available to the public. And the Department of Ed has a section in its website as well that indicates if an institution is on a probationary status, whether the institution is appealing that action. What this is saying is before you can go, full-blown lawsuit with the accreditor for taking that action, arbitration has to be an immediate step.
Does that answer your question, Amanda?
I think I just would want the results. I guess not the process to be like, just the results, the end result to be made public. Because it's pretty severe. The consequences are.
So the outcome of the outcome of the initial arbitration between the institution and the accreditor.
Right.
Throughout arbitration, it's all public. They're still under sanction. This is the sanction that is the public-facing decision remains in place throughout arbitration, throughout the lawsuit, until it is finalized one way or another. So it's always publicly disclosed.
So I think the sanctions occurred, and so irrespective of whether it's in arbitration or whether it's going to a lawsuit after that, the sanction remains the same. It's the sanction that the accrediting entity has taken, and that sanction is publicly disclosed.
Jody?
Yeah, I haven't fully absorbed this change in subsection E, but I want to flag that I have reservations about it, because if I'm understanding correctly, and again I'm skimming here, but it looks like you're effectively allowing any national or specialized accreditor to provide full access to Title IV dollars.
So if you go back up, and again, you're not scrolling, you're just looking up. But if you go back up to the section that describes where this applies, hold on a sec. I believe it is. That's it. Yeah, that's it. So it's under 600.5, and it's A5. B, and then B5, Romanet 1, B1. So it says, this is a proprietary institution, has provided a program leading to a baccalaureate in liberal arts as defined in paragraph E, which is the part that we're adjusting, continuously since 2009, is accredited by a recognized regional accrediting agency or association, and has continuously held such accreditation since October 1st, 2007, and that's part of the statutory requirement, and we can't make a change to that. So those are the two things that have to be in place. All we're changing here is what the regulatory definition of the program is, and we're just simplifying it. It's not something that changes the eligibility of these programs. And my understanding, though I don't have a list of the programs, is that this affects a very, very, very small number of programs at proprietary institutions.
That's a very good point, and I want to point out as well that. So going back to B1 again, as David was reading from before, just to flesh that out, this is accredited, has provided a program leading to a baccalaureate degree in liberal arts as defined in paragraph E of this section continuously since January 1, 2009. So there's also that calendar limitation on it. Also want to point out that when you look at yes, we're taking out the language that refers to the regional accreditation agency determining whether this is a liberal arts program. But if you look further on in E, going on to page 11, we still have stipulations there as to what that liberal arts program must be. So I think it's important to point out that we're not just saying to the school, you can make anything could be a liberal arts program without any limitations whatsoever. Still has to meet what's in 1, 2, and 3. Do we have any more comments on those sections? Okay. If not, we're going to move on to 600.31. And what we're doing here is modifying the definitions of a closely held corporation, parent, person, and the standards for identifying changes in ownership and control to more accurately reflect how those entities are considered under SEC rules. So
Page
let's go
25.
to, 600.31. Sorry.
Page 25.
Oh, sorry, thank you. Okay, so as we look down here on page 25 under 600.31, change of ownership resulting in a change of control for private, nonprofit, private, for-profit, and public institutions, that you'll see we have stricken the word corporation. Basically what we've done to here is taking out references to corporation and moving to referring to an entity so that it doesn't restrict our scope. You can see here as we go down to closely held corporation, means a corporation qualifies under state law of its incorporation or organization, so just broadening what that is. And again, if the state has no, if the state of incorporation or organization, broadening that to be where it's incorporated or organized. And you'll see similar changes throughout this regulation. And moving on to person, for instance, person includes a legal, used to be just a legal person, but now entity or natural person. What all this is reflecting, where we're talking about entities, is the department being is an evolution in the way a lot of institutions are held. So just from being a corporation to now being entities, and allowing us to look at these in a more broad sense. And Denise, do you want to make some clarifications on that?
No, I mean, that's pretty much it. It's kind of we're trying to, on the reg, evolve as to what we've been seeing in terms of the last 10 or 15 years. Structures are outside just the traditional what people think as a corporation, so that it captures for there's various components in here in terms of change of ownership, past performance provisions, things like that dealt with. The term before was corporation, and we want to make sure that it's understood that if it's in the structure and it's an ownership for Title IV purposes, that it's also considered under these rules, and it's not just a strictly held, say, S corporation or something like that. So they wanted to broaden it to say organization or entity to capture what we're seeing come up now instead of what was 20 years ago. So that's basically the need for the change there.
Leah?
Certainly, for-profit structures have gotten very, very complex with multiple levels of subsidiary structure in between the institution and the penultimate parent. I'm just wondering if this needs to be clear that we're talking about the ultimate parent. I don't know, but I have seen arguments made that, well, it's 3 steps below that the change is taking place, or something's happening at the ultimate parent that's really not affecting the school at all. I'm just wondering if we want to be very, very clear that we're talking all the way to the top of this change.
I think that's the intent, but I certainly will take that back, because I think that's also what we've been struggling with in the department in terms of change of ownership, nonprofits, conversions, enforcement, the whole thing. So
it should go to the very top of the organization. And I mean, I would argue to the top shareholder level. I mean, the individual people in control at the very top.
I'll certainly take that back.
Meredith?
I think mine was going to be similar, that in addition to wordsmithing the part on parent, I think it's just not clear enough.
Okay.
Leah, did you want to make another comment?
No problem. I just kind of lost track there. Okay, we're going to move next to 600.32, the eligibility of additional locations. Just broadly going over what we're doing here. We're removing the 2-year requirement found in 600.5A7 and 600.6A6. In
Page 28.
circumstances- Oh, page 32.
No, we're on
No, no.
28.
28. That's what I'm saying. You're on 600.32, right?
Right.
Okay.
We're on 600.32, page 28 of your materials. So we're removing the 2-year requirement in circumstances where the applicant institution and the original closed institution are not related parties, have no commonality of ownership or management, and the applicant institution agrees to accept liability for the closed institution's prior actions and its unpaid refunds during the current term and for one prior academic year, and to abide by the closed schools refund policies. We're also permitting an institution to apply to have a location that does not meet the 2-year requirement added to its program participation agreement if the institution is conducting a teach-out pursuant to a teach-out plan approved by both accreditation agencies. So the first one is, just as a recap, you're familiar with the 2-year rule, which requires an institution to have been in existence for 2 years and offering let's see if I get this right with my eligibility people here, continuously offering an eligible program in order for that entity to become eligible. So there is that consideration there. This change, I believe, would assist institutions that are purchasing institutions which have closed. That would make it so that they do not have to, so that the 2-year requirement would not be applicable to them if they, as we said here, if they have no commonality of ownership. So we wouldn't be allowing for one entity, one school within a corporate entity to purchase another one and have this waived. And also that they agree to accept the liability for the closed school and make all the unpaid refunds. So this is essentially facilitating the operation of a school without imposing that 2-year limitation where some other entity is coming in and purchasing that school. David?
So just one clarification. The first change adds an additional requirement for an institution to receive that sort of carve out to not have to undergo the 2-year requirement. The additional requirement is that there's no commonality of ownership. Yeah, we don't want cases where you're just trading off schools and you're avoiding having to operate for 2 years. So if you have questions about that, we'll stop first.
Jessica.
Thanks. I have some serious concerns about how this provision would play out. We've seen domino school closures where students, school is closed, there's like a career fair, other struggling schools come, take their students, call their cell phones over and over, take those students, 7 months later, that school closes. And I have some concerns about the way that this is setting it up. Specifically, the only taking on liabilities for 1 year seems deeply concerning. I think we all know, I'd have questions about how you'd imagine that interacting with borrower defenses. Those are not, I think it's unlikely that anything, the year span is really short, but even things like closed school discharge or, in the case of the school that closed near me, there was, an audit where Ed has a big claim from improperly paid Title IV funds, from 08, and now Ed is a creditor in the bankruptcy. It seems like that wouldn't fall under here. There's a lot of things that might go past a year. So I think generally just, trying to make sure that any institution that's coming in a closed institution is really doing the best they can for students and isn't just sweeping up students, avoiding some liability, and then hurting them again.
Want to take 5 minutes?
We were just discussing which one of us was going to answer you. The purpose behind this, because I deal with a lot, as I told you guys, of this kind of scenario with the regional offices too. What the department's trying to do is take away an impediment from other institutions coming in and setting up shop at that location. We're not trying to let anybody escape liabilities. The liabilities would still remain with the prior institution, but we don't want to stop them from coming in so that the student can possibly get a teach out and then they'll come in, because in reality a lot of schools don't want to come in and just do a teach out unless they, this is my experience, unless they can also maybe set that up as an additional location for their entity. So we're trying to facilitate possibly entities coming in doing the teach out so that the students can complete their programs. I understand your concern about another potentially faltering institution or what you were considering a bad actor institution coming in the scenario. But the department does still have to look at this and approve it. It's not an automatic, whoever applies gets to become an additional location. We do still do our due diligence and looking at all the factors, and I can assure you that the department does check for other things that have happened at the institution that wants to come in. So that's basically where we set up. I can let my colleagues, if they want to jump in as well.
A couple of things, though, to clarify why we're doing this. So first, your point is well taken about not wanting to see domino effects of one institution taking on a failing program and then failing right after that. And that's part of the reason for the language at the beginning here, where we say that you can't have, this doesn't apply when there's common ownership of the institution that's closed and the institution that's coming in. That's one protection that we've included. Obviously, if you think there are other things that we could do, we'll certainly be interested in your ideas. But the other part about the liability, keep in mind that this is talking about the incoming institution, the institution that one of the term that's sometimes used is the white knight institution coming in and trying to teach these students out. They want to purchase this location and start offering the program, but let's say this was a catastrophic situation in which the prior institution owed $500 million in liabilities to the department. The department already is unlikely to be able to collect those liabilities because of bankruptcy proceedings or other kinds of issues. And institutions that are coming in to help these students are going to say, well, I don't want this. I don't want this location. I'm not going to offer this if I have to take on $500 in liability. So this limiting language is designed to make it possible, number one, for the department to potentially collect some of those liabilities from the incoming institution, and number two, make it palatable for that institution to decide that they want to do this and start offering these programs to the students at these locations. And the last thing that we did here was our case teams pointed out that another limitation is that we had this language where a school couldn't come in and do this unless we had actually taken a suspension, termination, some other action, and that limited our ability to approve these cases. So this language is now replacing that, saying that the secretary has to evaluate and approve the plan, but we don't have to terminate someone necessarily in order to do that. So this is all designed to kind of make it possible for us to deal with these situations when they come up and let other schools come in and help. So anyway, to the extent that we can do that better, we're interested in your suggestions on that. But that's the point of this.
Leah. Oh, I'm sorry. We're getting blocked by that bottle. That's why. Jody.
It's Jody. Oh, go ahead. Thanks. Yeah, I actually initially had the same response as Jessica to this provision. And then the more I looked at it, and I'm not claiming to have the answer here, but I'm just wondering if this is something that would protect students in certain ways. I can see the trade-offs, right, if you're worried about students who lose out under the closed institution. But there is a cadre of students who potentially could be helped if you're incentivizing institutions to more stable institutions to come in and take over. So just a thought.
Verity or Leah, did you want it? You plaque it up or no? Oh, yes. I'm sorry. So you're recognized.
I wanted to point out that under the revisions for accreditation, there is language that says the addition of a permanent location at a site where the institution is conducting a teach-out for students of another institution that ceased operating. So it appears that you've connected the dots to not only allowing this provision here under eligibility, but you've connected it to making it specific that accreditors are paying attention to any additional locations being added at sites for teach-out students. Students in this situation are incredibly distressed. And when you're taking that on as an institution coming in, I mean, it's a huge commitment of resources. Typically, they don't get any money out of it. I mean, they are expending resources to handle the teach out, often in good faith, often as just a contribution. Very rarely is there any financial benefit to an institution coming in, taking over a location and teaching out students. It's a very stressed situation.
Meredith.
Yeah, I'd like to propose that we come back to this one at the next meeting. I find myself torn. I have pieces that make me nervous about it, and pieces, and having been at an institution that's worked with a number of teach outs, just making sure we define white knight closely enough that we don't have students going through this. I just think it's something we all probably need to go back and talk to our constituencies about, because this is key language, and I think we do want to enable the opportunity for people to come in and take it over and put these students back on the right track. But I share a lot of the concerns that have been mentioned, that we just think on this more.
We can certainly do that. Remember, we come back and we have 2 days prior to when we report back to the main committee. So there's nothing which it was just saying that we have to arrive at some type of a conclusion here today or any kind of recommendation. So that there's no problem with doing that.
Amanda?
Are there any scenarios where you saw this being done well, or was this more of a hypothetical scenario where it was coming from a framework, or your discussions were around, we want to help students ease through this chaos, maybe if we create this provision, and leaning on the side that it is a good actor, this would ease students' life cycle?
I'll start and then turn it over to my colleagues and who have more contact with eligibility. But I think that this is rooted, and again, going back to what Denise said, we have cases, a lot of instances where we have schools closing, and the need to accommodate students by allowing them to continue their programs. This allows entities to come in, sort of the white knight that you suggested before, and operate those locations and allow students to continue their education. As you can well aware, as you can well imagine, when students are faced with the closure of the school, it can be a pretty traumatic event for them. So this makes it easier for us to facilitate that without holding them accountable to the 2-year requirement that would otherwise be in existence.
No, I understand. I think I was just looking for an example. Is there an examples?
Well, I can't really give you a specific school, because we said we wouldn't talk about specific schools, but we have had plenty of situations over the last 3 to 5 years where we are trying to work out situations and we've had impediments, one of them being that there had to have been a subpart G case taken, which is our termination, suspensions, and a lot of our schools that are in trouble are not in that realm where you would have to take that action, because we have other forms, recertification denials and things like that. So we have had schools tell us that, we would have taken it, but there's a huge liability, or we would have to wait out 2 years, and then the students, of course, aren't going to get helped in those situations. So this is a real life concern, and we have seen it over and over and over again. And as Leah said, and I wasn't trying to downplay the schools coming in, because we do have schools come in that'll just do a teach out, but it is a significant expense for them, and especially in light of the fact that in a lot of cases where we have a bad actor school that precipitously closes, they've already taken the students' Title IV down, so that the school that's coming in, there's no more Title IV left for them to get. So they are doing it on their own dime. So we are trying to help take down any impediments. So this isn't something that was just hypothetical. We have had numerous situations over the years where the school can't come in and do anything because of our impediments. But we wanted to make sure there was no commonality to avoid, as Dave said, and as Jessica's concern was, where we have the domino effect, where they're just kind of moving their liability from one place to another.
And just one more piece of context. I mean, I think this ends up being most important where the institution that is attempting to teach out the students doesn't have a convenient location near where the students already were, because in many cases that's how they'll do it. They'll say, well, you can come and learn at this location, but if that's 100 miles away and students have been going to the same place for their entire college career, that's not an option for some students, and those students may end up discontinuing their education. So that's another reason that we're pursuing this.
Jessica.
Briefly, I think to the extent that Ed has examples in mind that are used to justify rule changes, it would be real. I know you maybe don't want that to be part of the discussion, but it would be really helpful if you could share that so we're all on the same page. And substantively, I just want to raise again, especially to Merity's point, that we're in a world in which Ed has proposed to take away closed school discharge for anyone who has the availability of a teach out, and that is a lifeline for people. And so I think, if we're living in that world, unless Ed is going to tell me that we're not living in that world anymore, I think that we really need to have a really high bar for what is a teach out, because it's really important, because people are potentially going to lose a huge right.
Go ahead, Anne Marie.
So I was part of those negotiations when we did that round of rulemaking last time, and we had written an NPRM. We are in the process of rewriting an NPRM, and the idea of that with the closed school discharge, where you would not be eligible if you had the teach out available to you, is no longer what we are considering. That is no longer the policy direction we are going. That will not be in the next NPRM that you see.
Thank you. Gregory, did you want?
Yeah,
to look at your
just as
time?
a summary, I think that. So I think that I don't see a lot of wholesale opposition to this. I think that what I'm sensing is that there's general support for it, but some of you have some reservations about the language and may want to put some more parameters around or think about what those might be. So I would encourage all of you to do that in the intervening month. Before we come back, we can certainly revisit this, and we'll make a note of where we are now, and there's no reason why we can't entertain that discussion again when we return.
Yeah, so I think we're getting close to lunchtime, but because I'm giving a mea culpa here, I missed something in my earlier discussion of distance education and correspondence. So I'd like to go back to it and just talk it through really quickly before lunch, if that's okay with our meeting organizer.
Well, since Dave has fallen on a sword, we'll let him go back and discuss what he missed. Yeah, sure, no problem.
What's that?
Quickly before lunch.
Yes. Okay. Yeah, the department, well, I can give you a definition of quickly, before noon. So I'd like to go back then to 600.7, which is where we define limitations on institutional eligibility. All right, and then I think if someone can find the correct page, it's on 22 of mine, but it might be on someone else. Sorry, 12. That's it.
Yep. Page 12?
Yep. So just as context, this section describes the limitations on an institution's eligibility, and there are various different ways. There are various different statutory limitations on eligibility. One of them is on incarceration. Another one is on correspondence students. So the limitation is that an institution can't have 50% of its students be correspondence students, and it can't have 50% of its courses be correspondence courses. So those are two separate and distinct limitations on eligibility. So this regulation currently has a description of what constitutes a correspondence course, but there, up until today, has not been a specific description of what constitutes a correspondence student. So what we did in under B, special provisions regarding correspondence courses and students, is we added a 2 that explains how an institution is to calculate the number of correspondence students. We feel this is important because it provides a critical definition for a critical institutional eligibility requirement. And I'll read the department's proposal for this. Calculating the number of correspondence students. For purposes of paragraph A12 of this section, and that is the part where it says that a school with 50% correspondence students is ineligible. A correspondence student is a student whose enrollment during an award year was entirely in correspondence courses.
Jillian.
My initial response to this provision was to be concerned about whether this makes it kind of easy to game the system, right? If it's easy to beat these restrictions by simply putting a student into a distance ed program to kind of evade being caught under this requirement.
Jillian.
So my question was, well, my comment was the same. I was wondering are you saying that this wasn't defined before, how an institution would calculate this?
That's right. There was no definition on how this actually would play out. There are a very limited number of cases where this calculation comes up because of the small number of institutions that are actually offering correspondence courses. But when it's come up, the department has taken the position that that even one correspondence course could constitute a correspondence student if they were taking one correspondence course during the year, and all the their other courses were residential. That isn't expressed anywhere in regulation, and so this the leadership wanted to make it clearer and change that policy somewhat so that it's clear to schools where the line is. Now we're interested in your opinions about where that line should be, about when someone is considered a correspondence student, but we felt that it needed to be expressed in regulation.
Yeah, I mean, this seems like it would create a pathway where if I wanted to make sure my students still had access to Title IV, I could have them take, I don't know, 15 credits of correspondence courses and then a 1 credit distance ed course that doesn't really have much content in it. And all of a sudden that school, all those students are eligible for Title IV when perhaps they shouldn't have been.
Leah.
Well, probably not before lunch, but this also goes to that regular and substantive definition issue. What happens when an institution goes through a program review and they're told, oh, those distance ed students are actually falling into your correspondence course category. And, are there any kind of conversations we need to have as a group about that? Because I think this definition has meaning when we've kind of decided once and for all the distance education definition, right?
Yes, that's correct, and there is a direct connection with distance ed in the sense that if an institution is not offering a distance ed course, it's offering a correspondence course, then a student enrolled in that correspondence course may or may not become a correspondence student under this definition. So, if you guys think that this language creates a loophole, we're interested in what we could use instead. We don't necessarily have to do it before lunch, but we're interested in your suggestions.
David.
I'm not sure if I have a great solution, but independent study is a lot like correspondence, and institutions do independent study all the time. So I would think that you'd want to have the option for students to do independent study / correspondence periodically as part of the curriculum, right? But you know what I mean? So the 100% rule is probably too much, but I don't know what
So what do folks think about a majority or a significant percentage or a majority or some other line?
Well, you have 50% for everything else.
I was going to say, as a lawyer, I would prefer not to use significantly or what are those other terms that can be interpreted 10 different ways by 10 different lawyers. But
Yep, point well taken from counsel. Does anyone have any thoughts about a majority, since that maybe is a better phrase, predominantly?
you need to come up with a number.
You need a number.
Because any of those terms, I can tell you'll have the rest of the lawyers in the room will agree with me that you're going to come up with 10.
You also have to make certain, as someone who's been, whether it's 50%, up to 50% and 50% or greater, that's got to be clarified, right?
Right. So, Verity.
But it's certainly something that we can. I'm sorry, Meredith, I didn't mean to. But we don't have to decide that obviously today, as we keep saying. If we can come up with something.
I was just going to say, I encourage us not to do the 50% just because it's in everything else. In my mind, a 75% sets a better balance because it does keep, if you're trying to load them up on correspondence courses, at the same time, the non-correspondence numbers are going up as well. But it hits some of our part-time students may take 6-9 hours a year. So 50% is a pretty low threshold. I think 75% comes closer. So I just threw that out for people to think about.
Yeah.
I was just going to say, I don't think, David, your example, I mean, if your independent study courses look like correspondence, they probably are correspondence, right? So there's still an expectation with independent study. I don't know why I'm having such a hard time remembering that term. Independent study courses that there is all of those things that fall into the definition of distance education. So I'm not sure we're solving for that right now, though I understand your point. And I had another thought, now it's gone. I don't know. Sorry.
Jessica.
Sure. I'm just a little confused. Maybe I'm behind the curve, but it looks like there are like 4 different 50% in this correspondence school thing, right? So like more than 50% of the courses are correspondence courses. 50% or more of the students were enrolled in correspondence courses. And then we have different correspondence students. So maybe this isn't like a 6-minute discussion, but I'm just confused about how those interact. And I think more to the point, you know, we don't want a scenario that can be gamed. That's all, you know, that we want. And so we don't want half the students in 49% correspondence and 51% of the students in 100% correspondence or whatever. Just, you know, rules that make sense.
We'll chew on that at lunch. Yeah, with your food. David?
So my point about the independent study is again to not single out online modalities as the only way to get correspondence, because independent learning study at an institution where a student is doing work with a faculty member, meeting with that faculty member maybe once a semester, handing stuff in, emailing, that looks a heck of a lot like correspondence, and yet we don't call it that, right? So that was my only point in bringing that up, and it, you know, percentage-wise, I don't have a dog in this fight.
My other thought I forgot, sorry, was just, I think there's definitions in probably 668 or somewhere else about calculation of aid for students in correspondence courses, and if they're in some correspondence courses and not others. I'm just curious, because I haven't given this any thought till right now, but like, how does this intersect with that, or does it not at all?
That is good context. So aid is calculated differently for correspondence courses. Correspondence courses cannot make a student go above half-time status for purposes of calculating their Pell Grant. And also, if you're in a correspondence course, the cost of attendance for that course is limited to tuition and fees, I think books and supplies. And so those are things that are true for correspondence courses, but this really isn't talking about the correspondence course. This is talking about solely this change, students that are enrolled in correspondence courses. So being a correspondence student really has no other application except the institutional eligibility application.
This is applicable to the institution. It is not applicable to the student.
Correct. This particular provision does not affect student eligibility per se. Yeah. And so I've heard a lot of good things around the table, but this is one I knew that we weren't going to get through this before lunch, but I figured you guys would want to take a little bit of time to take this back, think about it, and come back to us with some suggestions, and we're open to that. We don't want to create a loophole, but we also don't want to make it possible for a school to potentially get close to or lose eligibility inadvertently because they've missed something in these requirements. So we want to be careful about where we set the threshold, and that's what we're about with this regulation. So with that, I think we're almost.
Gregory, what time
noon.
would you like to?
We can close for lunch.
We're 5:10 after. That I mean.
Seriously.
All right. I'm going to be very because I'm so magnanimous here, and I want that noted for the record. 15 after 1, and I think
Thank you, sir.
That's huge. Huge. Oh yeah. Scott has pointed out, please take your badges with you for ease of reentry. Yes, if you're bringing back luggage after lunch in anticipation of leaving, we have places you can store it. Do note your luggage will have to go through the scanner.